788. It's a motion.
Duval Anderson?
Yes, Your Honor.
Okay.
And I would invoke the rule.
All right. To anyone here that's a witness in this case, rule of procedure has been invoked that you can't be in the courtroom during the testimony. You can't talk about the case with anybody except one of the attorneys if they come out too. You can't talk with each other about your testimony until you called in to testify as a witness, okay? So y'all will have to step out and then, unless one of them is going to be called. Y'all want to sit down?
Sure.
Ms. Cashwell?
I'm such a scam
I'll
to
tell you-
stand there like.
All right, you can stand up or sit, whichever way you want to do it.
Thank you, Your Honor. It's good seeing you again.
All right, this is, now this is on, I've got 2021 CF 2788 and 2021 CF 2789. And on that case, he's charged with battery and attempted burglary of a conveyance unarmed. And on the other case, the 2788, resisting an officer without violence, possession of drugs without a prescription, controlled substance without a prescription. So you got a motion to suppress.
Only on 2788, Your Honor.
Okay. All right.
Your Honor, the state would call Lieutenant Heath Hale.
Lieutenant Hale. All right, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God.
I do, sir.
Thank you. Have a seat.
Would you please state your name for the record
Heath Hill,
and where are you employed?
Okaloosa County Sheriff's Office.
And approximately how long have you been with the sheriff's office?
Approximately 12 years.
What is your current position and duties?
I'm the lieutenant over our Special Investigations Section.
Were you working back on October 29th, 2021?
Yes, ma'am.
What was your position back then?
I was a watch commander on patrol.
Did you go to 113 Southern Court in Crestview, Florida on that date?
Yes, ma'am.
And what was your reason for going there?
Routine patrols. We have a lot of stolen autos and things like that are dumped in that area.
Did you make contact with Yaquan Anderson on that date?
Yes, ma'am, we did.
If you would, please explain to the court what led you, where were you when you first noticed him?
The location where he was parked is a dead end. It's in an apartment complex. When you go in, the only way to get back out is if you turn around at the very end or pull into a parking space. When I went in, I went all the way to the end of the complex. There was a sold vehicle parked in the far corner. As I turned around at the end of the complex, I could smell the odor of marijuana. At that point, I was on the phone with Deputy Kane. And when we were coming back out, I pulled over. He came into the complex. We got out and made contact.
Because of the smell of marijuana?
That's correct.
So it was you and Deputy Kane that approached him?
Yes, ma'am.
Was this nighttime or daytime?
It was nighttime.
Do you remember the approximate time? It doesn't matter if you don't.
The report reflects just before 10 p.m.
Okay. So once you approached him, who approached what side?
I approached the vehicle was backed in. I approached the passenger side of the vehicle. Deputy Kane approached the driver's side of the vehicle.
Before you approached, did you notice if there were any other cars in the parking lot?
There were other cars, but this one was by itself. There was probably, reflecting back on the video, probably at least 4, maybe 5 spaces before the next vehicle.
And did you see any other people out there?
I did not, no, ma'am.
So you make contact, can you describe the vehicle?
It was a black Chrysler 200 with tinted windows.
So you approached on the passenger side, is that
I
correct?
did, yes, ma'am.
All right, and what did you do?
When I walked up towards the vehicle, the odor or the smell of marijuana got stronger as we approached the side of the car.
Were you concerned that a crime was being committed?
It smelled as if they were smoking narcotics, marijuana from within the vehicle or around the vehicle.
So what did you do?
Initially, we knocked on the vehicle's window, asked the driver to roll the window down.
Prior to that, did you have an opportunity to look around to see whether there was anything on top of the vehicle?
I did not notice anything.
So you said you knocked on the window?
Yes, ma'am. The window tint was dark. Initially, Deputy Kane thought 3 people were in the car, but it was just the driver's seat was laid kind of far back. And ended up only being 2 people inside the car.
What did you do?
While we were trying to get him to roll his window down, Deputy Kane indicated that he was making some movement within the car. He was instructed to roll the window down again. At some point, he cranked the vehicle, and after he cranked the vehicle, Deputy Kane opened the door. We were concerned that he was going to try to drive off in the motor vehicle.
So you said you were on the passenger side. What did you do? I mean, did you make contact with the other person?
Well, initially, when the vehicle cranked, I drew my firearm because we thought he was going to try to flee. We didn't know what was going to go on. But after Mr. Anderson was removed from the car, I did make contact with the passenger and asked her to step out of the vehicle as well.
Did you notice anything when you were having her step out of the vehicle?
Yes, ma'am. When she was still seated in the car after her door came open, there was marijuana shake on her lap, as well as being scattered inside the vehicle.
And did you talk to the person?
I did. As she was exiting the car, I asked her if she had a medical marijuana license, and she indicated she did not.
Did you get her name?
Yes, ma'am. She's logged in the report. It reflects Emmeline Roberts.
And she said she did not have a medical marijuana card?
That's correct.
When you go and make contact with citizens, do you wear a body-worn camera?
I do.
Did you on that date?
Yes, ma'am.
If I may approach, Your Honor?
All right.
I'm handing you something. Ask if you recognize it.
Yes, ma'am.
And how do you recognize it?
That's the copy of my body-worn camera video that I reviewed.
And how do you know it's yours?
I reviewed it and met with the state.
Put your initials on it.
I did.
Your Honor, may I publish the video, or at least parts of it, the relevant part?
Any objection?
No objection.
All right. Different than what we have down.
Yeah. That's not the issue, though.
So.
Put myself on 183 out on front at Appling Court Apartments. the side, so I'll turn the window into. Copy 47. 06 Alpha, Hotel Foxtrot Yankee 06A, HFR in black, car 61. Alpha. I can't see the magazine. There you go. The read's coming from this car. Roll the window down, boss. Roll the window down. What's the next person? Roll the window down. Roll the window down. You think some crazy? Don't do it! Don't do it! God dang. Unlock the door. What are you cranking the car for? He's in this lane. Hey! Hands! 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 Behind your back! 36, 1033, starting another car. That would be a big mistake. You understand me? Yes, sir. You better put behind your back and nowhere else, understood? Behind your back, that is it. Anything other than that would be an act of aggression, understood? I swear to God. I swear to God. Hey, hands on the dash. Nowhere else. That's all it is. Do not make it worse, okay? It's a weed odor right now, man. Don't make it a worse situation than it has to be. I got one single. Grind in here too. Don't go reach some ass, it's just some weed, that's it, brother. Step out from the top point. Left point. You got me on one car? No, sir, I don't. Thanks for listening. You got weed all over you, calling off for you to get in your car. Keep going. Is he behind you? Six car? You got any weapons on you? Could you bring that for me? So you don't have nothing in one car? Hey, find out who's got nothing in one car. You got money? She does, and she got weed all over her lap, so. Okay, he's saying he does, she does not. Let's pull the gun out, okay? I can smell weed when I turn around next to you guys, man. 36 to the 10. Slow everybody down. Let me use one call, please. Information call. 36, you can lower traffic. He said you got a warrant for his arrest? What's your name, partner? Okay, we'll get him in just a second. Okay. But you got, hey, listen to me, you can't go reaching in your pockets and stuff, man. That's how people get hurt. You don't know what you're doing when you do stuff like that, man. Come on, I'm going to put in this second, okay? I'll turn it off for you. She's got to see what we're running into. I'll turn it off for you, bro. Sit over here in the back. Cross your feet. She didn't know you was with him. He's not. She had me falling off the bathroom there. You made contact with her passenger side of the vehicle. You have to search your butt? About it. No, it's just hanging down on the waistband. I just want to... Got water. she doesn't have a medical marijuana card, and she had me all on the lap, so I walked up in the car, so it's a legal for her to possess it. So that gives us authority to search the car, okay? She can't legally possess it, and she's in your car possessing it, okay? Even if you got a medical marijuana card, she can't smoke it. You see what I'm saying? There's a whole bag of weed sitting in your door, you can't store medical marijuana like that. That's how you get your medical marijuana card revoked, because it's packaged for distribution. Well, I can charge her and charge you. Okay, let's go back to it's not going into your pocket when you got a marijuana. I'm definitely saying
Okay, I didn't hear what you said.
Oh, Your Honor, I'm sorry for saying, I just was objecting because I think we're way past the point of relevance.
Okay, sustain.
Stopping now.
All right, sustain.
Okay. And Lieutenant Hale, did you have an opportunity to speak at all to Mr. Anderson?
Briefly, I don't know that I asked him any specific questions that I recall.
Were you present when, did you hear the other officer ask him any questions? I'm not asking you to say what he said, I'm just asking, were you present?
The only question I recall hearing him, reflecting back to the body-worn camera, would be when he asked him if he had a medical marijuana license when he came from the vehicle.
And what was Mr. Anderson's response?
He said yes, he did.
And do you have the ability to verify whether someone has a valid medical marijuana card?
We provide their information to our communications section, and they do a search of it.
Were you able to determine if he had a valid medical marijuana card?
I believe it was suspended or expired, something along those lines.
Did you, in fact, search the vehicle?
I did, yes, ma'am.
Based on the search and your conversations and investigations, did you make any charges? Did you or the other officer file any charges in this case?
Yes, ma'am. The other deputy filed charges in this case.
Okay. And what were the charges?
I'd have to reflect back to the arrest report because I don't recall anything other than the controlled substance.
Okay, so did you find any controlled substance?
There were some tablets that were found on the top of the vehicle where his hand went when he came out of the car.
And what did you believe the tablets to be?
I believe they were oxycodone at the time based on their imprints.
Okay. And we heard discussion about weed, so is that marijuana?
Yes, ma'am.
And do you know if whether anyone was charged with marijuana?
I don't recall, to be honest with you. I can reflect back to the arrest report or the arrest narrative. It looks like he was charged with possession less than 20 grams. Or she, yes, he was. Let me look.
And is the person, the male driver, do you recognize him? Is he in the courtroom here today?
Yes, ma'am.
Would you ID him for the record?
The white shirt sitting left of the defense.
In Your Honor, if the record would reflect, he is pointed out to Mr. Anderson.
Record reflects.
No other questions?
Ms. Cashwell.
Thank you, Your Honor. Lieutenant Hill, right, did I pronounce that correctly?
Hell.
Hell.
Yes, ma'am.
Lieutenant Hell, we can hear you on the video ordering him at least 4 times to roll the window down. Would that be a fair statement?
I don't know the exact number, but he was told, yes, ma'am.
This was not a request. Sir, would you like to talk to us? This was clear that you were ordering him to roll that window down, correct?
Yes, ma'am.
And you would agree that the car was turned off when you approached it. Would that be fair?
Yes, ma'am.
And this is the windows, were they hand crank or electric?
They were electric.
And so and so when he was cranking the car, is it possible that he was trying to turn on the car so he could roll the window down?
The vehicle is push button. It does have an accessory mode where you would not have to crank the car
But we don't know if he even knows about the accessory mode.
I
can
can't
tell you, I
testify.
don't.
I do personally because I used to have a Chrysler 200,
Oh, okay.
but I don't know that he would know that.
Yeah, I have a Subaru and I don't know it. We can agree that also in the video that there was an order to unlock the door and then an order to show hands, right?
Yes, ma'am, there were.
And then you opened, or excuse me, Kane opened the door and then you opened the passenger side door?
I did, yes, ma'am.
When you opened the passenger side door, would you agree that we did not see a smoke flowing out of the window? In other words, we didn't see smoke. You know, you open the door, we don't see a big puff of smoke coming out of the car. You would agree?
Not during the initial contact, but there was when I opened the trunk. I actually made a reference on my body-worn camera about the smoke coming out of the trunk.
Did you find any burning blunts in the, blunts in the trunk of the vehicle?
No, there was one in the front driver's floorboard of the vehicle.
Now, you said that you smelled the odor of weed and that's why you went to approach this vehicle, right?
Yes, ma'am. Well, it was a combination of things.
And when you smelled the odor of weed, does weed smell like hemp?
Hemp is a low-concentration THC, so they would be similar, yes, ma'am.
Can you distinguish between the smell of hemp or the smell of weed?
No, not particularly.
If I burn hemp, can you distinguish the smell, can you distinguish between the odor of burned hemp and the odor of burned weed?
I've never tested that theory. I'm not an expert on the distinct odor difference between the two of them.
But you acknowledge that hemp is legal, right?
Yes, ma'am.
Okay. And you acknowledge that medical marijuana is, medical marijuana is legal?
If you have a permit or a license to possess it, yes, ma'am.
Now, so prior to ordering him to lower the windows, did you see any contraband in plain view?
I did not know, ma'am.
So it sounds like, and if I'm misstating it, let me know, that the issue was you have the odor of marijuana and you need to find out whether or not this is legal. You know, they have the right to have this marijuana. They have a medical marijuana card. Or if this is illegal marijuana, or if this is hemp. Would that be a fair statement?
No matter what, it's coming from the motor vehicle, and it's you can't be under the influence of a narcotic while operating a motor vehicle or in physical control. And he's in the driver's seat of the motor vehicle, and the odor is consistent with marijuana already being used.
Did you at any time do field sobriety exercises?
No, ma'am.
But so the question is, though, that when you were ordering him to lower the window, it was to ascertain whether we've got legal weed, illegal weed, we need to know. Would that be a fair statement?
Yes, ma'am.
Okay, no further questions, thank you.
Any redirect? Any redirect?
Only, no, Your Honor, actually.
All right, thank you. You can step down.
Thank you.
Next witness.
That would be Deputy David Kane.
You raise your right hand to be sworn. You swear the testimony you give for the course of truth, so help you God.
I do.
Thanks. Have a seat.
Would you please state your name for the record?
David King,
Where are you employed?
Okaloosa County Sheriff's Office,
And approximately how long have you been with the sheriff's office?
7 years.
What is your current duties?
Currently assigned as a corporal to Patrol Division.
Back in October of 2021, what were your assigned duties?
I was assigned to the Street Crimes Unit.
Were you working back on October 29th, 2021?
Yes, ma'am.
Were you working street crimes that night?
I was assisting with patrol at that time. We were having to cover shifts.
Okay. Do you recall what shift you were working?
I worked a split shift, so I worked Alpha and Charlie shift up here in North End.
And what does that mean?
I worked 12 to 12, so I covered half on one shift and half on another.
Who was your supervisor back then?
My street crime supervisor or supervisor on the road that night.
Supervisor on the road that night.
For that shift would have been Joe Trimboli.
And what was Heath Hale?
He was a lieutenant of that unit.
So would he also be considered a supervisor?
Yes, ma'am.
And did you receive a call to go to 113 Southern Court in Crestview, Florida?
I received a call from Lieutenant Hale, went and assisted him
And where did you assist him?
at 113 Southern Court.
When you got there, what did you do?
I got there and I went to the parking lot, started checking around because he had saw a vehicle. He gave me some information. I don't recall what all that was, but it was a vehicle of interest. I walked through the parking lot because I started to smell an odor of marijuana as I got closer to that vehicle. And then when I got to that vehicle, I determined that odor came from that car.
Have you ever been out to that area for calls before?
I don't recall if I have personally.
Do you know if the sheriff's office has ever been out there for warrant calls or anything?
Yes, ma'am, they have.
Did you notice if anybody else was in the parking lot?
Not that I recall.
Was that suspicious to you?
Yes, ma'am.
Was it just that nobody was there, or was the fact of the location of the car and the smell and all of the above?
Combination of all the above.
And why was that suspicious to you?
You have a car that's down on the very, very end of a apartment complex, backed in, and the car was off, but it's occupied, and you can smell an odor coming out of it. Could mean a few different things.
Are you concerned that a crime is being committed?
Yes, ma'am.
And when you started to approach the vehicle, did your concerns grow stronger?
Yes, ma'am.
And what was your concern?
Well, the concern was that when I walked up to the driver's side of the car, like I said, I detected that it's coming from that car, the odor of marijuana. So based off of that and what Lieutenant Hale had already told me previously, began to try to get the driver to roll the window down. The driver began to refuse.
How do you know the driver refused?
He would not roll the window down. We sat there for probably about 20 seconds without a window getting rolled down.
And what, if anything else, added to your fears or concerns?
I noticed that while I was standing there trying to get the driver to roll the window down, began reaching towards the front of his seat, his driver's seat. He was sitting in down beside the door. So at that point in time, I had concerns he also had a firearm he was trying to retrieve.
And so what did you say or do?
Kept trying to get him out of the car, at which point he decides to crank the vehicle up. So I figured at that point he was now trying to use the vehicle to get away from us. I opened up the door, asked him to get out. He got out, at which point...
Did he comply when you asked him to get out? Or did you have to get him out?
I believe he exited himself.
Okay. And what did you do next?
At which point, because of the fear that he possibly had a gun he was reaching for up underneath the seat, I went to go detain him in handcuffs. And at that point...
Did he comply or did he resist?
He started reaching for his waistband.
He started reaching for his waistband?
Yes, ma'am.
And what was did you have a concern then?
Yes, ma'am, that he was reaching for a firearm.
So what did you do?
I pinned him up against the car and tried to control the hands so that way he couldn't take a firearm out if he had one on him.
And did you end up patting him down?
So we got his hands up on top of the car, both of his hands, and then we got him in the cuffs. He finally cooperated and we got him in the handcuffs. And I don't recall specifically about patting him down at that point in time, but I believe I mentioned on body cam I did.
Did you speak to him? I mean, did you ask him any questions once you got him out of the vehicle?
The only thing I asked him was if he had a medical marijuana card.
And what was his response?
He said that he did, and then I asked if it was on his person. He said it was, and then later on that would change a few times.
Okay. And are you allowed to ask if, for the person's information,
Yes.
verify that they have a medical marijuana card?
Yes, ma'am.
And did you do that?
I asked for his name, yes, ma'am.
Did he tell you anything else?
As I was walking him over to set him down, he told me he had an active warrant.
Did he tell you his name?
Yes, ma'am, he did.
And what was that?
Jaquan Anderson.
And do you see him in the courtroom here today?
Yes, ma'am.
If you would ID him for the record,
He's sitting right over there in the white shirt.
if the record would reflect, Your Honor.
Okay, the record so reflects.
Did you have an opportunity to search the car, search him, any of that?
I did not search the car or him.
Did you charge him criminally with anything?
Yes, ma'am.
What did you charge him with?
Possession of controlled substance. Let me look back here at everything I got. Obstruction, resisting an officer, excuse me. Possession of marijuana, not more than 20, felony violation of probation, and possession of drug equipment.
Did you say the first one was possession of controlled substance?
Yes, ma'am.
Did you find a controlled substance?
There was a controlled substance found by the other deputies who searched the car.
Right, and where was the controlled substance?
On the roof of the car.
Did you have an opportunity to look at the roof of the car prior to all of this transpiring?
As I walked up, I did not because I was looking for occupants and seeing what they were doing.
Did you were you wearing a body camera on that date?
Yes, ma'am.
And did you have it on?
Yes, ma'am.
What kind of pills did you charge him with possessing?
Oxycodone.
And do you know where that was found?
It was found on the roof of the car.
You indicated that you did.
No objection.
That you had a body worn camera on that evening?
Yes, ma'am.
I may approach, Your Honor.
It's a disc with my initials on.
Is this your, have an opportunity to review it?
Yes, ma'am.
Is it your video body worn camera from that evening?
Yes, ma'am.
Your Honor, if we may publish at least the first part of it, just, you might see it from a different point of view.
Okay.
One back. Myself? Yeah. Probably got the seat running down there. Yeah. Go roll the window down, bro. Roll the window down. He's reaching. He's not back there, seat leaning up. Roll the window down. Roll the window down. Don't do it. Stop right there. Step out the car. Step out the car. Open the door. Nah, don't be reaching. Don't be reaching. Don't be reaching. He's reaching the guns. He's in his waistband. He's in his waistband. Hands. He's in his waistband. Stop doing it right now. Do not do anything right now. Do you understand me? Do you understand me? That would be a big mistake. Do you understand me? You better put behind your back and nowhere else. Understood? Behind your back. You understand everything going on? Listen, all we got right now, listen to me. But right now we have is odor of marijuana, okay? That's all it is. Do not make it worse, okay? So we don't know right now, man. Don't make it a worse situation than it has to be. Okay? Don't go reach the line. That's it, brother. I'm about to. I can't see her right now. Okay, that's all it is, man. All right, what you reaching for? You got no problem with me. Cause what? Cause what right there? You see how that can make that lot worse than me? Don't do that. Okay? I put you on a lot worse. All right, come on, son. You have a medical marijuana card? You don't? You do? Okay, so you do have it. Okay, you have it on you? Yes, sir. You have it on your line? Okay, she's saying he does, but she does not. Okay. Let's figure that out, okay? I can smell it. Yeah, we can smell it, man. All right? Is your medical marijuana card on you? I got a warrant, sir. You got a warrant? Yeah. Okay, what's your name? What's your name? Okay. Is your ID used? No, sir. What's your ID? I don't got it. Okay, give me a favor. Come out of there. Let me sit you down, okay?
When you find that a person, when they tell you that they have a warrant and you're getting them out of a car in a situation like that, do you search the car? Or do you just search the car because of the fact that you had the smell?
Are you saying strictly because they tell me, or I confirm they have a warrant?
Once you confirm they have a warrant.
If I confirm they have a warrant, then yes, I can actually do an inventory depending on the circumstances of where the vehicle's at, who else with the vehicle, a few other factors.
Ms. Cashwell, do you have a question?
Yes, Your Honor. Is it Deputy Kane?
Yes, ma'am, that works.
Or what is it supposed to be?
Official title is corporal, but deputy's fine.
Corporal. No, you earned it. I'm going to address you like that. So Corporal Kane, was there any BOLO for Mr. Yaquan Anderson?
For Mr. Quan Anderson, not that I'm aware of.
Was the car parked illegally?
No, ma'am.
Was the car reported as stolen?
Not that I recall.
So the car was suspicious because of the odor of marijuana?
And whatever Lieutenant Hale had told me previously, I don't recall what he told me, and I forgot to put it in my report.
Well, we're here today, so
Yes, ma'am.
here today, the car was suspicious because of the odor of marijuana. Can you distinguish between marijuana and hemp?
No, ma'am.
Is hemp legal?
Yes, ma'am.
Can you distinguish between burned marijuana and burned hemp?
No, ma'am.
And on that night, could you distinguish what kind of marijuana you had?
No, ma'am.
Would it be fair to say that the reason that Mr. Anderson was being ordered to lower his windows and, ordered to lower his window was because you wanted to investigate whether it was legal marijuana or illegal marijuana?
It's part of it, yes, ma'am.
You saw two people in the vehicle?
Yes, ma'am.
And you had a flashlight on the vehicle, is that correct?
Yes, ma'am.
You did not know either one of those people?
No, ma'am.
And you weren't responding to any call for service regarding the occupants or the vehicle, correct?
No, ma'am.
I asked that in a weird way. Is that correct? There was no call for service regarding this vehicle or these occupants?
Correct.
Okay. And when you flashed the light into the vehicle before you ordered him to lower his windows, you did not see any illegal contraband, right?
Not that I recall.
You did not see any guns?
No, ma'am.
You did not see any weapons?
No, ma'am.
Okay. And when you gave him the order to lower his windows, and it sounds like 3 times he was given an order to lower his windows, the car was shut off?
Yes, ma'am.
It was an electric car? I mean, I'm sorry, the windows were electric or manually lower? Could you manually lower
I
those
would
windows?
assume electric.
Electric, okay. And after you ordered him to lower the windows, then the car cranked up?
Yes, ma'am.
But you assumed it was to get away, not that he was trying to lower his windows?
Correct.
And when you ordered him to lower the windows, this was not an invitation or a request. It was a lawful, or in your mind, a lawful order, right?
Yes, ma'am.
Okay. And when you, you said you saw some reaching movement, was that after you had already issued the order to lower the windows 3 times?
All 3 times or just when I started giving the order?
I don't know, you tell me.
I don't recall. We have to watch the video again.
Got you. But would it be fair to say that you did not know what he was doing and you wanted to investigate that as well?
Correct.
So it sounds like, and if I'm incorrect, you tell me, but it sounds like the sole reason, the reason for seizing the person of Mr. Anderson and issuing an order for him to roll down the windows was just to make that determination. Does he have hemp? Does he have legal marijuana? Or does he have illegal marijuana? Would that be a fair statement?
Fair statement.
Thank you. What was his warrant for?
I don't recall what it was for.
And did you find any contraband on his person?
I did not on him physically.
Thank you. No further questions.
Okay, redirect.
Yes, Your Honor. She had mentioned legal versus illegal marijuana and hemp. Can a person operate a vehicle while under the influence of those?
No, ma'am.
All right. So is it fair to say you could possibly have concerns about a person being
Objection,
under the
leading.
wheel of a vehicle?
Hang on, what was your objection?
Leading, Your Honor.
You mentioned earlier, or she mentioned earlier, reaching movements. Did that create any concerns for you?
Absolutely.
Were you concerned? What kind of concerns did you have?
My ultimate concern is that he's trying to retrieve a firearm.
Nothing further.
Anything else? All right, thank you. You can step down.
Just one last question.
Oh.
Would it be a fair statement to say you at no time Mirandized him?
I did Mirandize him, yes, ma'am.
Okay, but after you'd already asked him the initial questions that we've seen on the body cam?
Correct.
Because you would agree on the body cam, we
Yeah,
didn't
yeah.
see you Mirandizing him.
Correct. I do later on when I get him set down on the side and after I get his name.
Okay, after you've already asked him questions. Okay, thank you.
Are you allowed to ask a person if they have a medical marijuana card?
Yes, ma'am.
Are you required to Mirandize them first?
No, ma'am.
Thank you.
All right, thank you. Step down. Next witness?
That's all, Your Honor.
If I could have one moment. I'll tell you, well, actually, we can bypass this. If the state will stipulate that he was seized at the time that the order was issued to lower the windows, then I don't need to put him on for him to testify that he did not feel free to leave. Would the state so stipulate?
All right,
Then we can move forward to argument, Your Honor.
all right, go ahead.
Thank you, Your Honor. Did the court, I sent the case law that I was going to rely.
I read it.
Perfect. Okay, great. I wasn't sure that the court was going to get it. Okay.
Got some case law, and it dealt with smelling marijuana as you approach a car. Is that what you sent?
I sent Well, she sent some case law from 2007, 2010, 2011 regarding odor of marijuana.
2021.
I sent case law from July of 2022, the Hatcher case from the first DCA. Did the court get that? Good, okay. On October 29th, 2021, at 113 Southern Court in Crestview, at approximately 21:58 hours, Mr. Anderson was legally parked in a vehicle, a jointly occupied vehicle. At that time, law enforcement,
Can those officers come back in now?
sure. At that time, law enforcement seized Mr. Anderson by issuing an order for him to lower the windows, for him to show them his hands when they opened the car door immediately. And I, think since we have a stipulation that he was seized, then we go to the next part of the analysis, which is, okay, if he was seized, then did they have an articulable suspicion of criminal activity to support that seizure? And the case that I sent and that I am relying upon regarding whether or not there's an articulable suspicion of criminal activity is the Kilburn case. And the Kilburn case is at 297 Southern 3rd, 671, a first DCA case. In that case, a police officer notices a truck with a translucent license plate cover, and it appeared that it was out of state, but he couldn't tell for sure. And he sees the defendant in the driver's seat. As soon as the driver sees the deputy, he puts the knife on the front seat of the truck and raises his hands. When he raises his hands, the police officer sees the butt of a gun in his waistband. So now here's the police officer, guy in a truck, raises his hand, butt of a gun. So the police officer is thinking to himself, okay, if he has a concealed permit to carry a concealed weapon, no problem, he's legal. But if he's a convicted felon, or if he does not have a concealed permit to carry that firearm, then he needs to be arrested all day long. So what the police officer did was at that point order him out of the vehicle in order to ascertain whether or not he was legally in possession of this firearm or illegally in possession of this firearm. Turned out illegally in possession of the firearm. So there was a motion to suppress. It went up on appeal, and on appeal, the first DCA said no. This would eviscerate the Fourth Amendment, and I want to, if potentially lawful activity, and said, quote, potentially lawful activity cannot be the sole basis for a detention. If this were allowed, the Fourth Amendment would be eviscerated. So law enforcement cannot say, well, I don't know if this is legal or not, so I'm going to stop you just to find out. And that's what we have in this case. Both deputies testified, yeah, I wanted to see if it was legal possession of marijuana or illegal possession of marijuana or legal possession of hemp, because we don't know. The Hatcher case comes around because there's a long line of cases that said the odor of marijuana can give you PC or can give you the reasonable suspicion. But then the Hatcher case came out in July of this year, 2022, first DCA. And in the Hatcher case, the police show up and they have an odor of marijuana. They have a driving pattern. And the coup de grace, they have a canine alert. And so they then seize the occupant, search the vehicle. In Hatcher, the defense attorney argued, look, the motion to suppress should be granted because you don't know if this is legalized hemp burning, because it smells the same as marijuana, or this is legal marijuana, or this is illegal marijuana. And the first DCA said, and if you look at the Hatcher case, the first DCA specifically said that they declined to address the scenario of whether the smell of marijuana it alone can give them an articulable suspicion of criminal activity, because we've got enough other stuff to rely on. We've got a driving pattern, we've got a canine alert, so we don't need to worry about this. So the first DCA in the majority opinion states that, but then Judge Bilbrey, I think he gives a brilliant concurring opinion. And Judge Bilbrey says, hey, I agree with Hatcher. I agree with Hatcher in this case, that the smell of marijuana alone is not enough to give an officer reasonable suspicion of criminal activity. Because and he cites down, and you can look on page 3, 4, and 5 of the concurring opinion, he says, things have changed since those long lines of cases that it could. Things have changed because now hemp is legalized. Because now we know that burning hemp and burning marijuana smells the same. Because now medical marijuana is legal. Things have changed. And because things have changed, marijuana on its own cannot form the basis for reasonable suspicion of articulable criminal activity. It just cannot. And then he goes on and he says, as a result, I respectfully submit that we should no longer rely on Johnson, that first odor marijuana case that came out, or Colley v. State it was also first DCA 2022. And he would urge the court to consider receding from Johnson and Colley due to the statutory changes. So what Judge Bilbrey does is he acknowledges things have changed. So these line of cases are out of date with the statutory changes that have legalized hemp and legalized medical marijuana. And he goes on to talk about the fact that the arresting officer testified that burning marijuana and burning hemp smell the same, which is understandable because they only differ by THC content. And he also talks about the changes that were codified in Section 581.217 of the Florida statutes, where it's now legal under Florida and federal law to smoke and possess hemp. The legislature found that hemp is an agricultural commodity and that hemp-derived cannabinoids are not controlled substance or adulterants. And then he goes one step further, which is, I think it's wonderful. In his analysis, he says, it cannot be an affirmative defense where the defense has to prove, I've got a medical marijuana card and so therefore it's legal. That's ridiculous. And he says that's ridiculous because the state has the burden of proving a case. So if the state, and I'll just cite to you, the state has to prove that the substance that the defendant possessed was cocaine as an element of the offense. It doesn't, as a result, a defendant does not have to prove that the substance was in fact legal. So, I mean, if they're trying to go the route of saying that, well, if they have medical marijuana, it's an affirmative defense, it's completely illogical and flies in the face of all of the other drug abuse case law, where that is upon the state to prove what the substance is and that it's an illegal substance. And he also says, he cites the Kilbourne case in his opinion. He says, Hatcher correctly argues that our case, Kilbourne v. State, supports his position. We stated that a potentially lawful activity, first DCA said this, a potentially lawful activity cannot be the sole basis for a detention. If this were allowed, the Fourth Amendment would be eviscerated. And a potentially lawful activity cannot be the sole basis for detention premised on a reasonable suspicion of criminal activity. So then the question is, okay, so if the odor of marijuana is not enough, what else do they have? And the state, I think the only thing that I heard was, well, he's parked at the very end, albeit legally, and it just seemed odd. And I kind of thought that the state might do that. So if you look at the motion to suppress, I cited a series of cases regarding a particularized and objective basis for suspecting car occupants of criminal activity. Observing a defendant's back a pickup truck into wooded area known as the site of illegal dumping does not give the officers any particularized and objective basis for suspecting criminal activity. That's Brown v. State at 687 Southern 2nd, 5th DCA 1996 case. Observing the defendant and another in a car parked in a driveway at 1 in the morning with the interior light on in an area where there's been a whole bunch of home burglaries does not give the officer a particularized and objective basis for suspecting the car occupants of criminal activity. That's Harrelson v. State, 662 Southern 2nd 400. That's a 1st DCA 1995 case. Observing the defendant drive out of a parking lot located behind a closed insurance company at 3 in the morning and pick up a female who is walking away from the business does not give the officer a particularized and objective basis for criminal activity. And that's Abraham v. State at 532 Southern 2nd 91, and that's a 4th DCA 1988 case. Observing a vehicle that looked out of place does not give the officers any particularized and objective basis for suspecting the car occupants of criminal activity, and that's Graham v. State, 714 Southern 2nd 1142. That's a 1st DCA case, 1998. Observing a car driving back and forth in front of a closed marina at 3:30 in the morning does not give the officers any particularized and objective basis for suspecting criminal activity. And that's White v. State. It's a Florida 2nd DCA 1999 case, and I'm sorry that I'm missing the citation on that. Observing the defendant parked late at night in a gas station that was the subject of recent burglaries does not give the officer any particularized and objective basis for suspecting criminal activity by the occupants. And that's Ippolito, IPPOLITO v. State at 789 Southern 2nd 423. And that's a Florida 4th DCA 2001 case. So when you look at the testimony in a nutshell, there is a lack of, there is not an articulable suspicion of criminal activity, and there's no case law that's going to support that odor alone of marijuana post the legalization of hemp, post the legalization of medical marijuana is going to constitute reasonable suspicion in light of the Kilburn case. I don't know if I need to address whether or not the search of the vehicle pursuant to the or to an arrest warrant. I don't know if I need to address that, but I'll go ahead and address it. The officer testified that he can search the car if he's arresting somebody, and there's no case law to support that. We have Arizona v. Gant, which I didn't bring because I didn't know he was gonna say that, but we all know Arizona v. Gant, the U.S. Supreme Court case that stands for the proposition that only if Mr. Anderson got out of the vehicle and had contraband on him would that give them the probable cause or give them the reasonable suspicion necessary in order to search the vehicle. But if all they do is Mr. Anderson gets out of the vehicle, he has an arrest warrant, and they arrest him, unless they know what the arrest warrant was for or they testify to it, and there's some possibility that the fruits of the crime would be found in the car, then that's not going to be a supported legal search. And so I don't think that that would be an alternative basis to allow for a search in this case. This is a dispositive motion. This is a first DCA case. It's an interesting case. And I don't know if I did bring some case law if the court wanted, there was no testimony regarding community caretaking. I didn't know if the court was thinking about that. But if the court is thinking about that, I've got case law that addresses that as well. All right, so I would ask that motion to suppress be granted. And finally, Your Honor, he was asked questions after he was seized, and there was no Miranda. Thank you.
Yes, Your Honor. So I think that Ms. Cashwell's made it clear that she's asking the court to create new law, to create law that goes against the current law that is in existence, current case law. Before I get into that, I wanted to address the cases that she has submitted and some of the arguments that she has made. First off, she keeps referring to a potential lawful activity cannot be the sole basis for a detention. If the court were to consider driving while license suspended and having a driver's license, it is perfectly lawful for an officer to pull someone over for having a suspended license. All they do is verify that the license is suspended if they know that person, and driving is a lawful activity. But they are allowed to pull them over for that, and they are allowed to ask them, do you have a license? They don't have to Mirandize them first, and that is a potential lawful activity that can be unlawful. So for the court and for who she picked for her argument to say that you cannot go that route, that stands in the face of what is already done every day. And the first thought that came to my mind was driving while license suspended and having a driver's license. And an officer is allowed to ask for a driver's license. An officer is allowed to ask if you have a medical marijuana card. One of the cases that she cited, and I think it was Kilburn, she was talking about the firearm and the extent, the analysis that the court went through, saying that you can't, that was wrong in that particular case, that the officer could not do that. There was differences in that case and in this case. You, as an American, are allowed to possess a firearm. It's a Second Amendment right. So, and the court in that case got into the discussion about lawfully being able to have a firearm. And in that particular scenario, person walking down the street and seeing a little butt of it, the butt of the gun sticking out. There was no other suspicion. There was no reason. So therefore, the officer had no reason to approach and admitted as much. This case before you is different. Drugs are not a Second Amendment right. There are only some drugs that are lawful. And the courts, even on the federal level, say smell is enough, the odor of marijuana is enough, but I will get to that. But the police, their job is to investigate crimes. They smell drugs. They are allowed to inquire. Do you have your medical marijuana card? Present it. If that's it, then that ends the discussion. They check it, it verifies, you move on your way. If they were to have said, it's hemp, well, the officers couldn't disprove it, so then the discussion would end at that point, and they would have to move on their way. But that was not the case. But they do have, that is their job, to investigate whether a crime is being committed. So it's very different from the gun case where you have a Second Amendment right to possess a firearm. The officers articulated it was dark, it was parked in the back, they'd been out there before for warrant service, that nobody else was out there, they're in the vehicle, and they smell marijuana coming from it. These are all different things that they articulated approaching the vehicle as reasonable suspicion to go further. They then talk about, the officer then mentioned the furtive movements once he's there and he sees him reaching around. He doesn't know if he's reaching for a gun. He had concern for safety. He didn't know if he's reaching for drugs. He's knocking on the window. He's asking him to roll the window down, an investigatory stop, asking them to provide some information. And everything there further just only solidified the fact that in their mind a crime was being committed, and in fact it was proven that a crime was being committed. In the Kilburn case, again, that had to do with a gun and him having it, and it was poking out, part of it was poking out of his clothing. In our case, it's the smell of marijuana, the fact that a crime could be committed, and Lieutenant Kane also mentioned, it's not just that, but you've got somebody in physical control of a vehicle possibly, and the smell of drugs. And it's illegal, it can be illegal to operate. There might be an issue of, do we need to proceed with a DUI evaluation? So, and that was another thing that was elicited from Lieutenant Kane about a possible crime being committed, and they have the right, and the public safety requires them to investigate. And the officer's fears were only substantiated in their minds even more when he cranks up the car. The totality of the circumstances, the officer's conduct, they did articulate the facts necessary. In Grider, the defense cited this case. That was a welfare check. The officer approached the vehicle and was just doing a welfare check. So they had no belief that a crime was being committed. They had no suspicion, and even said as much in the case. So that makes it completely different. In this situation, it was an investigatory stop because they're smelling drugs. Another case that defense cited was Gentles. This was factually distinguishable. Again, this was another welfare check case. And the focus was he gave a command to turn off the engine. He didn't have, and he even said in the case, I had no reason to approach him. I was just checking on him to see if he was okay. And the whole discussion of seizure, and he was seized and told to turn off the vehicle when he had no reason to believe that a crime was being committed. Again, different. They're smelling the drugs. This was not a welfare check. The last case, the Hatcher case, which is the case, of course, that the defense is asking you to take a step further and to change the current law. In this particular case, it was a traffic stop, and then there was a dog walk around the vehicle, then there was a search of the vehicle. That case is different factually as well, but Ms. Cashwell would like for the court to take the implied dicta from that case and make it the current law for the first DCA. That an officer is somehow not allowed to approach a vehicle or approach people if they smell drugs, and they're not allowed to question them, because it may be legal and may not be legal. That's the whole point of the investigatory stop. It's a brief detention to determine if a crime is being committed. And she's asking the court to modify that, to change that to where you no longer can approach. It's an officer's job to investigate any potential crime being committed. And Your Honor, next would move to our cases that the state is going to cite. Okay. state is going to refer to. The case state would first like to cite, and Ms. Cashwell is correct, State v. Williams, which is a 2007 case. It is pre-medical marijuana. It established that the odor of burning cannabis emanating from a vehicle establishes sufficient facts and circumstances to establish probable cause for a warrantless search of a person or a vehicle. Probable cause where the facts and circumstances within the officer's knowledge that the information is sufficient to warrant a man of reasonable caution in the belief that an offense is being committed. Your Honor, the next case the state cites is State v. Jennings. Smell of marijuana gave probable cause to search the vehicle. The smell coming from an occupied vehicle provides that same reason to approach. Your Honor, the next case the state would cite is United States v. Roberts. That is a 2021 case. This is post-hemp, post-medical marijuana. 849 Federal at 863. 11th Circuit for the South Circuit of Florida held that police possessed a reasonable suspicion of criminal activity, and the reasonable suspicion was sufficiently particularized, being the smell of the odor of marijuana as they approached a group of people. That was enough reason to detain and investigate. In that particular case, the individual said, you don't know who was smoking the marijuana, who it came from, and you could take it a step farther, whether it's legal or illegal, but the court said it is enough the smell alone is enough. That's 2021. And if you read that case, it does cite numerous other cases that say the smell of marijuana is still the standard. It is still reasonable. It still gives reasonable suspicion for an officer to approach a vehicle or approach a person and to make inquiries. There's also the case of State v. White. It's a 2010 case, 593 Federal 3rd at 1199, that the court has previously held the smell of marijuana alone may create reasonable suspicion of criminal wrongdoing. Now, Lieutenant Hale indicated you've got the issue of the drugs, and then you've got the issue of, and then there's the issue of whether it's legal or illegal, but then you've also got the issue of a person being in control of a vehicle and having drugs. So everything was proper under Terry. The state believes that the suspicion was sufficiently particularized and that the officer's conduct was proper. Although it came in a roundabout way, the testimony was that drugs were found on top of the vehicle, not inside the vehicle, and that there was nothing, I believe it was Kane, that indicated there was, not Kane, sorry, Lieutenant Hale, nothing was noticed on top of the vehicle before. But the officers, when they began this contact with this individual, they had all the different reasons that I've already stated, but then after they make contact, they have non-compliance, not rolling down the window, scrambling around, moving things around, and everything else that I've already said several times, Your Honor. But the state believes that the current case law, federal and state, is that the smell of marijuana alone is enough. And we believe that it is appropriate that the court continue to recognize the previous rulings by the other courts as that being the standard, and to not take implied dicta from another case a step further.
Can I have brief rebuttal? I'll make it brief, and I'll try and go point by point. Number one, any federal case law is inapplicable here because federally, marijuana is illegal. Obviously, state medical marijuana is legal, so it would be inapplicable. Number two, I'm not asking the court to create new law. What I'm saying is that and if I may approach, I've got the two pieces of case law. What I'm saying is that the line of cases that has emanated from the first DCA has reached the point where we're at right now, the recognition that after the legalization of hemp, that since you cannot then say that reasonable suspicion of criminal activity can rest solely on whether or not it's a legal or illegal possession. So and I'm not saying that the police can't approach. You know, under Popple v. State, there's 3 different levels of approach. So, for example, let's go to the firearm case. Sir, I see that you have a gun. Do you have a permit for that? That's a citizen contact, no problems. That's not what we have here. We have an immediate stipulated to seizure without an articulable suspicion of criminal activity. The state attorney says, well, you can always stop somebody to see if they have a license. Actually, no. The DWLS case law states that, number one, you have to be able to identify the driver and know that that driver recently has had their license suspended. So if you know that the driver, for example, 3 months before had his license suspended, that's not sufficient. It's got to be more recent in time for you to not only recognize the driver, but know that his license was suspended and you just checked on it. Then, yes, you can pull him over and say, hey, you don't have a license, or do you have a license? But you can't just willy-nilly pull people over. The only exception to that would be the roadblock. But then you have special statutory conditions that you have to abide by. You sound like you have what I have, Your Honor. The other 2 state cases, Jennings and Williams, again, that's all prior to the legalization of marijuana. This is actually simple. It's really simple. All this is recognition of statutory changes that have occurred with hemp, statutory changes that have occurred with medical marijuana, and therefore the concept of steroidasis or desis, depending on how you want to pronounce it. Therefore, our case law changes along with it. And Bilbrey is just, Judge Bilbrey, I don't mean to be disrespectful, Judge Bilbrey is merely pointing that out in the concurring opinion. And he says, this case, Hatcher, that is not the issue before us, because with Hatcher, we had other things. We had a canine alert. We had a driving pattern. And that leads me to my final argument. The argument that there was any kind of thought that they had a DUI is absolutely, there's actually a line of cases regarding reasonable suspicion for a DUI. For example, if somebody crosses the white line once, that's not enough. If they cross the white line and the yellow line and they're weaving within the lines, that's enough. So there's even a line of case law for DUIs as to what will actually constitute reasonable suspicion of DUI. And we have no testimony, no facts here that would support that. So I would respectfully ask the court, I'm not asking the court to make new law, I'm asking the court to follow the line of cases that's been developed by the first DCA and has been almost, I don't know what you would call it, foretold by the concurring opinion by Judge Bilbrey for this case, and grant the motion to suppress.
Anything else? Well, the court appreciates the presentation of counsel. These are always difficult decisions, just like these officers have difficult decisions to make. They have a very dangerous job, but we also must be mindful of the rights of citizens. The court finds this is a close case, but the officers testified that they smelled marijuana as they approached a particular vehicle, or as they followed that smell, they approached a vehicle where the smell got stronger. They requested the defendant to roll down the windows, which he refused. The keys were in the ignition or placed in the ignition. He turned on the car as if he was trying to leave. He refused to remove his hands from his pants or comply with the officers. All that activity combined with the smell of marijuana, which increased as they approached this vehicle, the court feels provided the reasonable suspicion for them to search the car and do the investigation, so that respectfully, the court denies the motion to suppress.
And would the state stipulate that this is a dispositive motion?
Yes.
Thank you.
Okay. Would you provide me an order? Thank you. Is there anything further?
I think this is set for, these two cases are going to be set for pretrial conference on October 24th. So I will speak with my client, and then we'll go from there. All
Okay.
depositions have been taken in both cases, so it's ready.
And I want to thank you for the presentation of both counsel. You were well prepared, and I read the cases. Thank you.
Thank you, Your Honor.
Any additional required?